2023 has overall been a bad year for Pakistan. We're going to talk about the judiciary in particular and certain key decisions of the judiciary, as well as the court's role with regards to democracy and elections, fundamental rights, the trial of civilians in military courts, the protection of minorities, and the administration of the Supreme Court. Coming first to democracy and elections, the courts were twice involved when it came to elections. Firstly, earlier in the year when the provincial assemblies in Punjab and Khyber Pakhtunkhwa were dissolved, and later in the year when the National Assembly and the remaining provincial assemblies were dissolved. As regards provincial elections in Punjab and Khyber Pakhtunkhwa, the constitution expressly states that when a provincial assembly is dissolved, elections are to be held within 90 days of dissolution. This is what the Lahore High Court held, this is what the Supreme Court held. Bizarre excuses were heard for not holding elections on time. The lack of funds, the security situation, simultaneous provincial and national elections, even though the constitution says no such thing. Ultimately, the Supreme Court, headed by former Chief Justice Umar Ata Bandyal, held that elections in Punjab are to be held on 14th May. And directions were issued. The federal government was ordered to release funds for the elections in both Punjab and Khyber Pakhtunkhwa. The federal government was ordered to make available all necessary personnel, whether from the Rangers or the armed forces, for elections. Justice Munib Akhtar, who authored the majority judgment, stated that the Election Commission of Pakistan is not the master but rather the forum which has been entrusted to conduct an exercise which is at the heart of any constitutional democracy, and that is elections. The Election Commission of Pakistan does not have the power to unilaterally alter the election date, and it certainly does not have the power to alter it in a manner which goes beyond the constitutionally stipulated time period. Ultimately, a decision of the highest court was defied, and the people of Punjab and Khyber Pakhtunkhwa were deprived of their right to be governed by their elected representatives. Later in the year, when the National Assembly was dissolved and the remaining provincial assemblies were dissolved, the court once again heard petitions regarding delay in general elections. This time it was after the census was approved. The 90-day limit lapsed in early November. The Supreme Court, headed by Chief Justice Qazi Faiz Isa, simply stated that the Election Commission and the President have come up with a date for general elections, and that date is 8th February 2024. Since this exercise has been taken and the federal governments and the provincial governments also concur on this date, the matter of general elections stands resolved. And the 8th February 2024 election date is arbitrary. It has no constitutional basis at all, and any delay in general elections, whether that's 3 years or 3 months, derails democracy. It has also been a terrible year as far as fundamental rights are concerned. Enforced disappearances continue with no accountability. The International Convention on the Protection of All Persons from Enforced Disappearances defines an enforced disappearance as an arrest, detention, or any other form of deprivation of liberty by agents of the state or those acting with support of the state, followed by a refusal to acknowledge the deprivation of liberty. In an enforced disappearance, there's a role of those acting with support of the state or agents of the state itself. In Balochistan and parts of KP, we've seen how enforced disappearances have impacted citizens disproportionately, and more recently, politicians, journalists, bureaucrats have disappeared only to reappear weeks and months later. In the case of politicians, this is only after they agree to renounce certain political affiliations or they leave politics altogether. Harsh and oppressive laws have also been used to stifle dissent. The message that this sends is that a whole host of frivolous cases can be registered, and despite the fact that you've been granted bail, you can still be kept in custody. When Justice Babur Sittar was hearing Shandana Gulzar's case, he stated that provided she does not leave the territorial jurisdiction of Islamabad, she will not be arrested in any other case. This is a sensible and rational order when faced with a situation where the executive authorities are displaying a complete lack of regard for court orders. This has been seen especially in the case of women in Lahore who were detained post 9th May. They've been granted bail in many cases against them. They're being rearrested, and ultimately maintenance of public order laws are also being used against them. The courts have not been able to stop this blatant disregard of their own orders. As far as the trial of civilians in military courts go, post 9th May, 103 civilians are in military custody, and there were various petitions which were filed filed in the Supreme Court challenging the trial of civilians in military courts. The argument against military courts were that they don't comply with fair trial standards. There's no right to a reasoned judgment. There's secret trials. Serving army officers act as judges. And it essentially creates a parallel judicial system. A 5-member bench of the Supreme Court, headed by Justice Ijazul Ehsan, held that Section 21D of the Pakistan Army Act, which allowed for the trial of civilians in military courts for certain limited situations, is unconstitutional, and the court unanimously held that the civilians in military custody are to be tried by the ordinary criminal courts or such special civilian courts which are established under the law. Less than 2 months later, when a hearing appeals against this decision, a 6-member bench of the Supreme Court suspended this order to the extent that it struck down sections of the Pakistan Army Act. Now, the reason the suspension order is problematic is because to get an order suspended, you have to show some irreparable harm. And what irreparable harm is caused by a civilian trial before a civilian judge, and essentially that is what the court has said by suspending this order, that a civilian trial before a civilian judge causes irreparable harm. As far as the rights of minorities go, once again, there were many cases of desecration of places of worship of minorities. In this regard, there's a decision by Justice Tasadduq Jilani, which was given in 2014, where he gave various directions to the authorities, including the government, that a special police force is to be established with training given on protecting places of worship of minorities, that special curriculum should be developed in school for the promotion of religious tolerance, and that the law enforcement agencies will take prompt action if there's any violation of the law or if there's been any case of desecration of places of worship of minorities. The judgment of Justice Tasadduq Jilani has not been fully implemented, and it falls to the court to ensure that decisions which have been given are implemented in their entirety. As far as the administration of the court is concerned, for the first time, the Supreme Court's proceedings were televised live, and now a link is available on the Supreme Court website for proceedings which take place in courtroom number 1, which is also where the Chief Justice sits. While there is a risk that by televising proceedings and making a live link available, some may play to the gallery, ultimately, this has led to an increase in transparency, which is a good thing. The Supreme Court Practice and Procedure Act was also primarily upheld. This altered the way that benches on the Supreme Court are constituted. Previously, the Chief Justice was the master of the roster and had the authority to constitute benches. This law gave the authority to a committee of judges comprising of the Chief Justice and the next 2 senior-most judges. A right of appeal has also been created against decisions of the Supreme Court handed down under Article 184(3) of the Constitution, which is also called the Supreme Court's original or suo motu jurisdiction. Although the court did not uphold the retrospective right of appeal, the prospective right of appeal for decisions going forward has been upheld. The detailed decision of Justice Qazi Faiz Isa on the Practice and Procedure Act has been released. There are still many questions which are unanswered as to how a new constitutional jurisdiction can be created through ordinary legislation when Item 55 of the Federal Legislative List only permits enlarging the jurisdiction of the Supreme Court. How can an entirely new jurisdiction be created, as there's a difference between creating and enlarging a jurisdiction? Does Article 191 of the Constitution in and of itself confer legislative power on Parliament to regulate the practice and procedure and the internal workings of the Supreme Court? And where does the right of Parliament to regulate the Supreme Court stop? So there are a lot of questions with regards to the Practice and Procedure Act which still have not been answered. In short, as far as this year is concerned, the people of Punjab and Khyber Pakhtunkhwa have been unrepresented for almost a year as a decision of the highest court was defied. There are over 103 civilians currently in military custody, and they have been in military custody for the last few months. Oppressive laws have been used to stifle dissent. Maintenance of public order laws are used as a last-ditch attempt to keep individuals in custody. Enforced disappearances are still taking place, disproportionately impacting those in Balochistan and parts of Khyber Pakhtunkhwa. And the women who were detained in Lahore post 9th May are still in custody despite getting bail in cases against them. New cases are registered, and they are also being detained under maintenance of public order laws. Overall, in 2023, Pakistan has regressed.